That's all the discovery I have in my possession. This is a DVD of the stop.
Okay.
Officer Thornton. The LPD police report, the lab report. These are going to be my witnesses plus my expert. I'm going to give you a copy of this.
Okay.
The lab submission form, the DPS lab form, the in-car here, and then the DIC 23, 24, 25, book and sheet, inventory. I just put all that together. And then, of course, the PC search warrant affidavit. Here's a copy of all this. I'm fixing to go make another copy of this so I can file it with the court. What we do is I will sign it, and then you need to sign it, and then I'm going to file it with the court so there's no question about what you got.
Okay, did y'all respond to everything that I asked for?
Yes.
Okay.
What else? Is there something that you're
Well, I don't know, I
seeing
haven't,
that-
I'll need to look through it and...
Yes, the witnesses, the experts, all the evidence. You got the, we don't provide copies of the information, those are in the clerk's office.
I got that, I did get that myself, but,
Okay. The offense reports. Everything that the PD gave to me, I could given to you. I have nothing that they have not given to me. And then the video.
your evidence, aside from allegations or opinions, that a valid cause of action was presented?
Right there, the offense report.
Okay, where's the part that y'all are wanting me to sign?
It's just to show that you received everything, and I've checked everything I've given you. And I'll sign it. This is just your copy. I'm gonna go make another copy, and then actually it'll just be you. You can mark out attorney if you want, and then I'm gonna file it with the court to show that all this was provided. And I'm gonna say on the record what I gave you to. And that's our
Okay.
discovery laws, the 39.14.
Okay. So you want to keep that until you make your copy?
I have it on my computer.
Okay.
This is for you.
This is mine,
that one
and then
here.
I'll sign something
This one's
else.
yours also. And then that's just, what you're gonna sign is just showing that you received everything that I have.
According to that
39.
code? Okay.
Yes, and I will be right back. I'm gonna make another copy. Do you have any other questions?
No, I'll just need to go through all this and,
Do you work or anything?
are you asking because I'm here every day?
I was just curious.
I do jobs where people voluntarily pay my salary or pay for what I do,
Like kind of
side jobs or whatever.
because you have a really low, I'm not saying you can't represent yourself, but you have a really low blood test.
Mhm.
You were barely over the legal limit, so you might want.
My whole deal is, to have a valid cause of action, somebody has to actually be alleging that they've been victimized.
The state, that's how all of our cases get filed, it's the state. That's
Okay,
the
but
victim.
the state's a fiction. It's just something that's made up, and you can't hurt something that.
Are you in some kind of?
Are you telling me the state isn't a legal fiction?
This state is not a legal fiction, yes. When you drive on
Yeah.
when you allege yourself to her laws and drive on her roads, then when you violate the law, then you can be held accountable. And that's what all of these are. Every time we get a case, the victim is usually, unless it's an assault or assault from violence or criminal mischief of some kind, then the victim is the state.
But where's the actual injury?
The injury is that you were driving over the legal limit on the public roads, and the law is .08, and you were barely over .08. That's why I really think you need to get an attorney. But if you want to continue this, we can. It's just going to be a waste of your time because she's not going to allow it. This is stuff that goes through every day. That's why I kind of was just trying to be upfront and real. If you want to subject your time to this, that's fine. We can do this. We can go through all this. I'm okay with that. But I'm saying you're barely over the legal limit. So just think about that. It could possibly be worked out another way. That's why I think attorney.
Another way by
involved.
going on probation?
Well, it would probably be a probation of some kind. It just might not be a DWI because you were so close to the legal limit. I went ahead and filed it anyway because you were over the legal limit. It's .08, but you're very close.
Kind of like bringing it down to obstructing traffic or something?
Something like that, yes.
Okay.
But this isn't really, this is just getting the discovery to you. But that's why it's just something you need to think about, because it could probably be worked out another way.
Okay.
And sometimes attorneys, that's why you have attorneys, because you know you didn't go to law school, so you might not. They can advise you on what would be best. I can't advise you because I work for the state,
Right.
but they could advise you on what would be better for your license for the future, besides having a DWI conviction. But if you want to continue, totally fine. I'm going to go make a copy of that. Do you have anything else? Everything else is going to be
No.
on the record. Do you have any other questions about anything?
No. No.
And I didn't, usually I, redact stuff, but it's you, so I'm not redacting anything because
Okay.
you already have, your information.
Okay. So when we reset, that's just going to be for.
I don't actually know what she'll reset you for, because
Okay.
usually she doesn't let anyone go pro se. This is the first time I've seen her go this far with someone pro se. So I don't really know what she plans on setting you for next.
Okay.
Probably.
Well, I'll go ahead and let
trial.
y'all know that I'm going to go through y'all's discovery, and either tomorrow or the next day, I'm going to have a motion dismiss and see if.
Dismiss?
Yeah.
Okay.
And we'll see if she holds y'all to y'all's burden of proof.
On the motion to dismiss?
No.
She's not going to, because you were over the legal limit. And
She's
there
not.
was enough probable cause to
Okay.
the arrest, and there was enough for me to file the information on it.
Okay.
That's something that she doesn't dismiss the cases, we do.
Right.
And if we don't get
But-
there, then we go to trial or a bench trial, or, there's other avenues.
Okay.
Are you gonna
We'll
want a
see.
jury trial long term? Is that what
If
you're looking for?
if I continue to force to come here and go through with all this, then
Go through with all what?
continually coming back when I don't feel there's a valid cause of action, that I hurt anybody. I still don't believe I hurt anybody.
Did you get the information around you in open court?
Against the peace and dignity of the state,
Uh-huh.
my peace and dignity is being violated right now.
Okay. Are you with
Do
the
I have a
Republic
valid-
of,
No, I'm not a
you're
Republic
okay.
of
I've had a lot of
Texas.
those lately, so I'm kind of.
And I'm not a sovereign citizen.
Totally through with dealing with them because they've been everywhere lately. Okay,
Oh.
well, your arguments are a lot like theirs, so that's why I was asking.
I don't believe I'm in any state, so
Okay.
they believe.
They're their own
Yeah,
state. You believe
mhm.
you're not in any state.
I just haven't seen any evidence that it's actually true. Aside from the opinions of these people that call
Officers.
themselves government.
Okay. Okay, well, I'm gonna go get some copies. I'm gonna ask you to sign that when we get back,
Okay.
just saying you received everything. And then I'm gonna file.
Saying that okay, I got you.
You can, if you wanna say that you, I think, make sure that you have everything you asked for,
Well,
but I'm
I
pretty
mean-
sure I gave you everything, but
Okay.
if there's not, tell me and I'll get it. I have
Okay.
everything that they gave me.
Okay.
If there's something else that you're wanting, we can get that on the record, but
Okay. It's up to y'all to prove your case, so, I asked for things that I think are relevant, and if y'all didn't give it, I'll go through all this and we'll see. But if I feel that y'all didn't give me something that I think is relevant, it's not up to me to tell y'all, you didn't provide this.
okay, see, that's where you're wrong again. This is where the discovery compliance form, I have to give you everything I have in my possession. I've given you everything I have that the
Okay.
agency has turned over to me. That's a new discovery law that just came in last September, okay? So I have to give you everything or I get into trouble. So I want you to go through there and make sure that you understand what I've given you, okay? That's, I
Mhm.
checked all these things, and then if there's something else that you think that you should have that I haven't given you, let me know. I don't have anything else in my possession. I've gotten everything I have from the PD. That's how they hold their stuff, and then they bring the cases over to us. I have everything I have from LPD that they have. But look through that, because this is the whole point of this hearing, is this 39.14. We're not doing really
Yeah.
anything else today.
Right.
This is just saying I gave you everything I have, the discovery.
Right, according to that. Yeah, I get that.
Okay, that's all we're doing today. If there's something else, then you can tell the
If
judge,
there's-
but she'll probably,
Well, if there's something else, like I said, I plan on filing a motion to dismiss. If there's something I feel y'all missed, I'm just gonna add it to that,
okay,
and then we'll go from there.
okay.
All right, today we discussed the docket, and Sue, have you provided all the discovery discovery and mitigating evidence in Mr. Davis's case to Mr. Davis at this point?
Yes, Your Honor, I met with Mr. Davis. I actually filed a discovery log and acknowledgement with the court. We've gone over the offense report, supplemental report. I've given him a witness list, a lab report, the expert report, probable cause affidavit. He has a copy of the in-car video, the DIC 23, 24, 25, booking sheet, motor vehicle inventory, a copy of the search warrant affidavit, and I've asked him to sign that to make sure that the court is aware and it's on the record that he's
So
received
there was a
all of
warrant
that.
obtained in this case?
Yes.
And what was the result of testing?
It was .087.
7.
Okay. How long, what period of time from the time of the stop and the time of the test, do you know?
I'm not sure. Your
Do you know, sir, between the time you were stopped and the time that the blood test was taken?
I'm not sure.
We have discussed that, Your Honor. I have talked to him about how low his breath test is, and that it might be a good idea to get counsel to advise him on a situation such as this, since his breath test is so low. That is not the issue. The issue is that he does not believe that there's a victim in this case. So it really has nothing to do with
Mr. Davis, the state of Texas is a complainant. The Constitution says that you can be charged by information or indictment. In this case, it's the information. You've had the information read to you. I don't understand what you mean there's no victim.
Is there somebody real that's actually claiming that I injured them?
You're not charged with injury. You're charged with driving.
Isn't that what a
while
valid, doesn't that create a valid case, an actual injury to somebody?
Well, no. The state of Texas is against the peace and dignity of the state. Driving while intoxicated is the allegation. There's no allegation of injury, and the state's not required to prove any injury.
But I am being accused of a crime, correct?
You're being accused of violating a law of the state of Texas.
Then
That is part of our penal code system, yes.
is it considered a crime?
It's an offense.
So is that a yes or a no?
Well, sir, you cannot say crime or not crime. I'm telling you, you are accused of committing the offense of driving while intoxicated in violation of the Texas Transportation Code and the Penal Code. The word crime, you won't even find in the Penal Code. It's a term that you're using, and commonly it's called criminal conduct, and we have a code of criminal procedure. But the allegation is that you have violated a law.
Okay. I'm really not feeling well today. I got all her discovery that she wanted to give me, or that she's required to, whatever. I do plan on filing a motion for dismissal. So I don't know how this is going to get reset, but can I have a few days at least to prepare that?
Sure. Are you going to continue to represent yourself?
Yeah.
You want me to set this for a pretrial conference? Is that what you're wanting?
A motion to, I don't know, y'all's procedure.
Well, I guess what you can do is you can file your motion and then present an order-setting hearing, and that will be set for a hearing.
Okay.
And it'll be on your order-setting hearing, your date. You get your date from the coordinator.
Okay. So file in a couple days and then,
In the meantime, I'm setting this for mandatory appearance docket for August the 29th. You've had a formal arraignment. That will be the next stage of these proceedings. If you want to file motions, that's up to you. Always attach an order-setting hearing to any motion, and you'll get a hearing.
okay. So do I need to sign something again?
August 29th, the reset letter for mandatory appearance is what you need. So have a sit in the front row. Jason, yes.
You wrote 2 there, and it says 8, so.
Yeah, just, it's because we never have these set for this date.
Docket, I think we're gonna call it later,